Hello. Morning. Can everyone hear me and see me? Yep. Yeah, good. It's very strange doing it this way. So, um, just to wait for a few more people to attend, but if we can just have a quick introduction. My name is Sharon Auld. I'm Head of Legal Services at Neathouse Partners, and I've attempted to put together an overview of the Employment Rights Bill. And it's not an easy thing to do because obviously it's a bit complicated. So what I'm going to do is run through the key points. The idea is that we will update this and provide another webinar in a month's time once we get more and more information about how things are going to be put in place. If you have any questions, I'm happy for you to come off mute and ask as we go along. Alternatively, we can wait till the end. So I think we're just looking at who's here and who isn't. So we'll just soldier on, I think, if everyone's okay with that. So we're going to look back over what has come into play. And then we're going to look forward to the wonderful things that are going to happen this year and next, and how you as a business, obviously with ourselves, can prepare. I've also thrown in a slide on the new rates so that you can all keep that and use it as a point of reference. So 2024 and beyond. So what have we got so far? As you're probably all aware, flexible working changes have come into effect. So an employee is now entitled to make 2 requests in any 12-month period. Oh, sorry, somebody can't see the presentation. I will leave that to our marketing guy. Can anyone else see it? Yes. Oh. Right, so it's looking like most people can see it. So I will. Right, okay. It's very weird webinars, aren't they? Can't see anyone. Anyway, so an employee can make 2 requests in any 12-month period. Now, the difficulty for employers at the moment is that the employee now has the additional rights. Do you remember previously there used to be a list of things that we could give back to the employee by way of rejecting a flexible working request? The employee now no longer has to explain the effect any change would have on the business and how it can be dealt with. So historically, we used to be saying, well, you tell us how we can accommodate X, Y, and Z. So there was more of an emphasis on what the employee had to do. Fortunately, that's sort of flipped now. And it's down to us really to justify our actions. We can't just outright refuse a request. And I mean, I'm hoping most people do go through the process anyway. Decisions have to be made in 2 months rather than the usual 3 months. So therein lies a note to update policies if it hasn't already been done. The Act doesn't introduce, as it says on the bottom, doesn't introduce a day 1 right, but this was introduced by the Flexible Working Amendment Regs. which came into force last year. You'll remember that last year we had the flexible working day one, we also had the holiday changes, etc. So we're just basically moving on from last year's change. So with flexible working, what I would suggest, and unfortunately it's going to be all you guys who are going to have to do it, revisit your policies if you haven't already done so, which I'm sure you have. Revisit your policies and update them. Pretty simple changes really for policies, but it is important that you have this in your handbook the day one, right? It just doesn't help the business, but if you can protect yourself with your policies, that's all good. If there's any questions, flexible working, happy to take those, but obviously it's a non-advice. So as well as flexible working, this may affect quite a few of you, to be fair. The Employment Allocation of Tips Act 2023. This is quite a significant change, but also a necessary change, I think. I'm not sure how many of you have worked in hospitality where you just get divvied out tips at the end of the week, and you know, there's no fairness to it. X got X amount and Y got Y amount. So the purpose of this is to make sure that workers received, as they've put it in the Act, tips, gratuities and service charges in full, and they're allocated in a fair and transparent way. I don't see this as a detriment to employers as such, because clearly the employees are getting tips. All you're doing is storing those tips and distributing them fairly. They call it the trunk system, which is very strange. And the person who deals with it is the trunk master, which I have to say always makes me chuckle. So where qualifying tips, gratuities and service charges are paid to the employer's place of business, and this is key, more than occasional and exceptional basis. So i.e. it could be, they're usually weekly, daily, etc. In order for you to be legally compliant, the employer must have a written policy on how it deals with tips. In addition to that, that policy has to be reviewed every 3 years. We have already had clients come to us with policies, trunk policies, amended, etc. And they're pretty straightforward things to do. And as I say, they merely ensure that the employee is getting what they have worked for effectively. I've included there an award. What the award is the Tribunal Award from the date of the conduct. So you'll see here, it goes back to October 2024 to April 2025. The maximum award for that period was £5,000. April 25 to April 26, £5,135. So as you can see from that, it's quite important, if this does affect your business, that you get your policy in place. Put a policy in place or paying £5,135. It's a no-brainer really, isn't it? So that's what we are pushing clients to do, and then to diarise it so that every 3 years we update and review your policy. Now, I'm sure most of you are up to date with sexual harassment and prevention. We did send out a policy and training document previously. So on the 26th of October 2024, Section 40A of the Equality Act came into force. The Worker Protection Amendment of Equality Act 2010, Act 2023, just to give us a mouthful, trying to get that across. So, as you'll be aware, employers are required to take reasonable steps to prevent sexual harassment of their employees during the course of their employment. Reasonable steps, therein lies the question, what are reasonable steps? It's going to be quite onerous for you to not take reasonable steps, and reasonable steps has not been identified. So what we would advise is that you put in place a stringent policy on sexual harassment prevention, maybe undertake training for managers and or general employees. It's going to become harder to defend a sexual harassment claim because we don't know as yet what reasonable steps are. So it's going to be, along with very many more of the regulations put forward in the bill, it's going to be very much down to a tried and tested approach. I've put at the bottom, you may wish to take practical steps, risk assessments, reviewing, circulating policies and procedures, sending on people on training courses. It would be helpful also to actually define to the best of your ability within your workplace what amounts to sexual harassment. It's very wide-ranging. And there is also a third-party application. So you have to ensure that third parties are aware of your sexual harassment and prevention policy. In practice, that's going to be really difficult for you to do. You can't control third-party contractors, etc. All you can do is ensure, it goes back to, oh gosh, sorry, I was trying to point at that. It goes back to reasonable steps. So if you have your policy, your procedure, your risk assessments and your training in place, that's the key point to start. Hopefully you all have those. And if you haven't, then that is something that you'll need to touch base after this. Employers will face both a financial penalty, an uplift to the compensation payment, and potential investigation by the EHRC and enforcement action. So it's all pretty serious stuff, really. And when we move forward into another slide, there is a Fair Work agency who will become responsible for managing, enforcing, etc., any breaches of the bill. So another leave entitlement to add to your family-friendly policies. Neonatal leave. This has been talked about for an awful long time, now effective. So you're entitled to 1 week of neonatal care leave, so we call it NCL, for each qualifying week a child spends in neonatal care up to a maximum of 12 weeks. Must be taken in weekly blocks. The care must begin within 28 days of the child's birth and it lasts for a period of at least 7 days. So that month, effectively. So you would be claiming once the child has been cared for up to 28 days. The employee must have qualifying parental rights. Again, this applies to adoption, parental leave, etc. It's a day one right. You'll find as we go through, going back to flexible working, most things will certainly moving forward become day one rights. Employees must comply with notice requirements that you will have in your neonatal care leave policy. And employees have the right to return to the same position. I think I'm covering that with my little head, aren't I? Circumstances to return to a suitable job or an alternative job. If you think of that as being very similar to the coming back off maternity leave, you won't go far wrong with that. So view it as another one of your family-friendly policies. What I would suggest is, in part, to review those policies, set up a section of your handbook as family-friendly policies, because these will be set to increase as time goes on. There are other elements within the bill that will come into effect. So if you start now with the neonatal care leave, you can move forward from there. Statutory neonatal care pay. The employee must have at least 26 weeks continuous service ending with the relevant week. The employee must have received normal weekly earnings for a period of 8 weeks ending with the relevant week of not less than the lower earnings limit. Now, this all sounds very complicated, but when I show you the rates, you'll see that they're all the same. All the family-friendly rates and requirements are the same and or similar. Employees who are taken or have recently returned to work from neonatal care leave are entitled to be offered suitable alternative employment on redundancy. Key here, in priority to other employees. Again, as I said before, if you consider this as almost a redundancy provision, so how you would deal with maternity leave coming back, you deal with neonatal care leave in the same manner. So if you are going through a collective redundancy, any family-friendly leave effectively should be given priority. Employees are protected from detriment or dismissal relating to neonatal care leave. Not a surprise there, very, very similar to what has been in place in relation to most family-friendly policies, maternity, etc. So, just mentioned the rates. Family-friendly leave. This is more of a crib sheet for you, really. So it's the same, £187.80, 90% of average earnings, whichever is lower. So that's SPP, SHPP, SPBP, and neonatal care leave. So you'll be fully aware of those rates that went up in April. Statutory sick pay, £118.75, and statutory maternity pay, you're aware of the 90%, thereafter £187. I've also included, as part of a crib sheet, the tribunal rates, which have also increased. Hopefully you won't ever have to look at these, but in the event that you do, unfair dismissal basic award, this equates to a redundancy pay. So if you're ever in a tribunal situation and you're looking at a schedule of loss for a claimant, to calculate the unfair dismissal basic award, just calculate that what they would receive if they were to be made redundant. So the cap on that is 21,570 for some reason, up from 21,000. So that's the max basic award that anyone can get. As you'll be aware, on tribunal hearings, there's also, you get your basic award, then you get your unfair dismissal compensatory award. Compensatory award is effectively loss of earnings. A little bit more complicated than that when you get into the nuts and bolts of it, but that in effect is what it is. The effective date of termination, if it was, now a lot of tribunals are still ongoing which is why I've put effective date of termination back. So from the 6th of April 24 to 5th of April 25, the max is 115, 115. So if you have a tribunal case ongoing from that point within that period, that would be your cap, and it would be calculated on that basis. It's now gone up to 118,223. Sounds like a big figure. It's the maximum. So, you know, we don't want everyone panicking that that's how much they're going to pay, but it is the maximum figure. Ordinarily, I would say you look between, I would say 6 months for a max award. That's not including the uplifts that we've referred to in the previous slides. So any uplift for failing to follow any procedure will be 25% on the compensatory award. You then have what we call vento bans. Vento bans are injury to feelings. So if you're claiming discrimination, or if someone's claiming, not you, if someone's claiming discrimination, you'll often find within their schedule of loss a claim for injury to feelings. These fall into 3 bands, which are updated each year. Lower band is for a one-off act of discrimination. That ranges between 1,200 and 12,100. More than often, you will fall somewhere in the middle of the lower band of vento. The middle band is for a continuous act of discrimination which has an effect on the claimant. It's, you know, it's a matter of fact as to whether it falls within the middle or top band. You would need to look at the case individually, but that's 12.1 to 36.4. And then we have the biggie, the top band. That's for continuous, substantial effects on the claimant of an ongoing discriminatory act. 36.4 to 67, 60,700, sorry. Very rarely, I say, touching wood, do you get the top band? But it's just there for your reference, really, if you do get a tribunal hearing. So that's where we are so far. And as I say, I don't think we've got any questions before we move on. Right, we have the grand finale. I say grand, and I say it in the loosest possible way. I tried to read through the Employment Rights Bill, and it's quite an intense piece of legislation. It's quite complicated, and it's going to be continuously reviewed. There is no finality to it at the moment, which is why, as I said at the beginning, we will continue to have these webinars as soon as anything comes through. A lot of it is going to be decided, unfortunately for employers, by cases. So where we have the bill saying things such as reasonable, you have to act reasonably, that's going to be down to test cases, effectively. I mentioned the Fair Work Agency. So this is going to be a created department, effectively, another one, who will be given various legal powers where your or employers are in breach of any of the provisions contained within the bill. The proposals so far say that the FWA can issue notices of underpayment, including national minimum wage, SSP, holiday pay, going back up to 6 years. but uprated to current rates. That, when I saw that, I thought it was a little bit, yeah, a bit taxing for employers, because it really does show that you will need to get these things right. Historically, you could go back and it would be paid at the previous lower rate, but this seems to be uprated. So we all know what a nightmare we've had with holiday pay, with the lock case, Bear, Stringer, all those cases that went through regarding holiday pay, back pay, including commission, including overtime. We've now got a further one that came from the recent case, she says, looking for that quickly, Harper Trust. So we're going to have to really consider your holiday pay policy and contractually. So you'll need to set out in detail entitlements to holiday pay and make sure that it is paid correctly. You'll see here going back up to 6 years, you'll recall that holiday pay was reduced and limited to 2-year backstop, but the Fair Work Agency will have the entitlement to go back 6 years. SSP, briefly, as you know, SSP now day 1 right, no further 3-day waiting period. And again, it's not the best for employers who don't have a sick pay policy in place. National minimum wage is another one, and it's so easy to say, well, I pay national minimum wage, but then you have things like if the employee is paying for uniforms, they have a pass for a canteen, they have an allowance for food, and any deductions that come out of their salary for those may take them below minimum wage. So minimum wage is something that you do need to be mindful of, even if on the face of it, it seems like everything is compliant. The only reason I'm stressing that is if you worked out the 6-year loss, if you work out the 6-year loss, then it could be quite a considerable sum. As far as I'm aware, the day 1 is now effective. And hence the reason why it's going to impact those who don't have sick pay policy in place. So you would need to ensure that you update your sick pay. Yeah. It can issue penalty notice 200% of the underpayment, a maximum of £20,000 per unpaid worker. So, again, it's just quite scary, isn't it? You know, the amount that you could potentially have to pay is quite concerning. And in addition to that, if you look at the third point, they can bring employment tribunal proceedings and give assistance to workers to recover costs. So not only are they coming round and fining you for 6 years for not doing something, then charging you 200% of the underpayment, they're then going to go to a tribunal and provide legal assistance to the workers. It's crazy, and it can recover enforcement costs from the employer. We're not sure how that's going to work yet, but as you can see, those 4 bullet points in itself are quite onerous, to say the very least. In practice, enforcement officers entering your premises shall have inspection powers and the ability to seize items where necessary. Almost a bailiff type approach, isn't it? Which is not good. However, on the positive side, it's going to take about 18 months to 2 years for this agency to be created. So we need to use this time to make sure that everything we need to do, we do. So we need to make sure we've got everything in place for holiday pay, minimum wage, sick pay, etc. So that when the FWA is introduced, we are legally compliant. So we've got SSP, flexible working, tipping, prevention of sexual harassment, neonatal leave. That's in place. However, there are huge changes that are not in place as yet, but will be. I mentioned previously family-friendly policies, things like bereavement leave. There are numerous things that are going to come into effect that we will cover in the next webinar so that you are fully prepared for any changes that come about. But there are changes now, as I've said here, these are the most significant changes in employment law in the last 50 years, which is quite considerable. And I think it was work pays was the idea behind it, to get everyone into the workplace, to give employees more protection. So for employers, the onus is on you to ensure that we have everything in place to make sure we don't fall foul. Fire and rehire. I'm sure a lot of you have come across, yes, going to make work pay, sorry. Is that right, Sarah? So fire and rehire. In July, on the 18th of July 2024, a new statutory code of practice and re-engagement came into force. So it was a code of practice similar to ACAS code of practice that was put in place. So the fire and rehire proposals contained within the Employment Rights Bill shouldn't be a surprise, because these are already, it is already a code of practice. It's going to be enhanced by further restrictions in the Employment Rights Bill. So we've got our list of automatic unfair dismissals, haven't we? The usual health and safety, etc. So there's going to be a new automatically unfair reason for dismissal if the employer sought to vary the employee's contract and the employee did not agree, and, here's the key, and is seeking to employ another person or re-engage the employee under a varied contract of employment to carry out substantially the same duties as the employee carried out before she was dismissed. So the scenario that we get quite often is you've got to introduce new terms and conditions, you want consistency in the business, you need to ensure that the business remains profitable, all those different scenarios where previously we would have spoken to the employee, consulted with the employee, but consultation is slightly different to non-enforcement, if you like. So whilst we would have consulted with the employee, that's not necessarily to say that we would not have enforced the change in any event. More often than not, there is still a role there. It's not a redundancy. It's a position where you need new terms and conditions of employment for a variety of reasons. So the role will still be, in effect, a valid role. So where you're seeking to employ another person or re-engage the employee under varied contract, they're going to be carrying out substantially the same duties, aren't they? The only thing you're changing is the contractual provisions relating to that role. So more often than not, you're going to get caught by the fire and rehire. It's fire and rehire, fire and replace. So if you replace them with somebody else to do the same role. So again, it's quite a far-reaching provision. So it's automatic, unfair dismissal. So how can we avoid it? Because with the best will in the world, as employers, there are times when there is no alternative, and we need to fire and rehire on new T's and C's. So the only way you can avoid the unfair dismissal, if you can satisfy the two narrowly drafted conditions. They would be narrowly drafted, wouldn't they? So the two conditions, and it's an and, you have to satisfy both of them. So the reason for the proposed variation, firstly, is to eliminate, prevent, or significantly reduce, mitigate the effect of any financial difficulties which at the time of dismissal were affecting or likely in the immediate future to affect the employer's ability to carry on the business as a going concern or otherwise to carry on activities constituting the business. Sounds really wide, that, doesn't it? Sounds like you'll be able to get away with it if you need to cut costs, redundancy, or if you need to change someone's T's and C's because of salary restrictions, etc. So on its own, that in itself would give us quite a lot of leeway in order to make the changes and avoid unfair dismissal. However, you've got the and the and is that in all circumstances, the employer could not reasonably have avoided the need to make the variation. So that's the sticky wicket, so to speak, isn't it? Because could not reasonably have avoided. Again, that needs to be tested. That wording is not clear, as is a lot of the wording not clear. So how could you not reasonably have avoided the need to make the variation? I suppose in the circumstances, you could look at whether you could have cut costs in another way, or you could have saved money on a sick pay scheme that you're looking to reduce or remove. So there are various options you have available, but point one is the key. So we would have to be looking at a business rationale, much like you would do for a collective redundancy or a redundancy. Have your business rationale in place prior to going through with the proposed change. If both conditions are satisfied, that's not the end of it, is it? The tribunal will then go on to consider whether the fairness of the dismissal and the virtual test on reasonableness. So is the dismissal fair? Is it reasonable in all the circumstances? So now, rather than the two elements of the dismissal to be overcome, you've now got four effectively. But it can still be done, but it can't be done as frequently as has previously been the case. Now, this is one where I'm sure everybody has been reading up. This is the most radical change to unfair dismissal law in the past 50 years. The right not to be unfairly dismissed will become a day one right. They've confirmed this will not take effect until autumn 2026. I remember when unfair dismissal was 12 months. And then it went up to 2 years, showing my age, but hey. And that itself caused quite a few issues with employers. Now we're going to day one. It's going to make recruitment, etc., onerous on businesses moving forward. Potentially, is it going to affect the people you employ? Yes, in a nutshell. So the Employment Rights Bill achieves this by making changes to the Employment Rights Act to remove the current requirement that employees must have 2 years service to bring a claim. So that's all they've had to do, is take that out. And the automatic rule now is that it's triggered at day 1. The bill, however, does refer to dismissal during initial period of employment. So you will have heard everyone, or you will have heard people mention statutory probation period. So that is looking at being between 6 to 9 months. So the potential fair reason of capability, conduct, illegality, or some other substantial reason applies from day 1. If you put in place your statutory probationary period, then that gives you the opportunity to review. That gives you the opportunity to review the employee's work, etc., in that time. And I would suggest that everybody puts in place a probationary period in the contract, which you should have. However, it needs also to be a policy. It needs to be a separate policy on its own. If you have extended the probationary period, does that fall under initial period of employment? Oh, sorry, missed that. I would say that you would need to make sure that you put that in your policy, but it doesn't make sense if it does include initial period of employment being extended, because in which case you would just keep extending the probationary period in order to potentially avoid the day 1 right. So my feeling and my advice would be, set your probationary period up to the max, continue to review during that period, but I think any extension will fall foul of the statutory probationary period. Because thinking about the intention behind the bill, if we allowed extension, it would no longer be a day 1 right, would it? Because we would continue to extend. So we need to be quite careful on this one. And I think this is going to be the significant shift. And I think this is where employers are going to tighten recruitment so that you are going through a recruitment exercise that gives you the right people. We all know how difficult recruitment is. You know, you recruit someone, you interview someone, they come across great. It's not until sometimes after the current probationary period, hence as was the question that was just asked, hence the reason why you extend it, that things don't work out. But I think we're going to find that employees are going to use the initial statutory probationary period more often than we currently use the standard probationary period and extensions, to avoid the risk of a day 1 claim. You'll see at the bottom, the fact redundancy is not included means employees will be entitled to claim unfair dismissal in relation to redundancy from day 1. Irrespective of the probation period, redundancy is an overarching day one right. So a government amendment to the bill amends the legal definition of initial period of employment. As I say, it's going to be, it says 3 to 9 months. 6 months to 9 months would seem to be the most reasonable. I don't feel that you necessarily can determine whether someone is capable of doing the role in 3 months in a lot of circumstances. And because of the risk, I think you'll find that people are going to be on probation for a longer period of time. Any process an employer must follow in order to justify a fair dismissal will be determined by regulations made by the Secretary of State. So we don't know, is the answer at the moment. It says, or what I read was that a lighter touch approach will apply during the initial period. But again, we need some clarification before we can put in place strict policies to assist in probationary reviews, etc. But you will need to get things in place now. Government amendment also gives the Secretary of State the power to cap compensatory award for employees who are unfairly dismissed during the initial period. So basically what they're saying is, if you're dismissed during the initial period of your employment, it's not as catastrophic as if you've been there for 5, 6 years. So they're going to cap it, which hopefully will work in favour of the employer, in that you're not going to be facing such huge tribunal awards. So withdrawing a job offer. So again, day one right. As you know, if you withdraw a job offer because an employee hasn't satisfied certain criteria, there is an element there that the risk is breach of contract. That's the worst case scenario. Ignoring the protected characteristics, it would be breach contract, so it would be then notice pay if you didn't pay it. This bill leaves that in abeyance, and the right to claim unfair dismissal will not apply to dismissals occurring before employee has started work. Unless, there's always a but, isn't there? Unless the job offer was withdrawn due to specified reasons. So I'm sure a lot of you put that, you know, it'd be subject to satisfactory references, right to work, etc. Largely replicate the current list of automatically unfair reasons to dismiss. So again, you can't withdraw a job offer on a protected characteristic. So nothing really has changed in that respect, but it includes job offers withdrawn due to an employee's spent convictions, political opinions or affiliation, or membership of an armed reserve force, which I've never come across, but you may have done. So withdrawing an offer, that's fine. Just keep in mind the issues that you previously ensured were in place. Limitation periods. Yeah, tribunal. 3 months less a day is going to be no longer. It's highly likely that the bill will extend limitation date to 6 months, which is not ideal because, you know, at least the 3 months less a day, again, extended by ACAS conciliation in majority of circumstances, at least you had a sort of quite early end date to the risk of litigation. 6 months is much the same as it would have been for breach of contract. So it's very likely that's going to come in. It just means that the employer needs to be more mindful of potential claims, and if it's a replacement, if you're replacing the role, rather than waiting for 3 months, you're now waiting for 6. So again, there is going to be an impact on business. Another proposed non-governmental amendment is extending the time limit for sexual harassment claims to 12 months. That's going to be quite onerous, and I can't see that going through, but I'm not putting any bets on it at the moment. All bets are off. Again, that would just be pretty onerous on employers to manage. And it goes back to the beginning where we discussed the fact that all your policies and procedures need to be in place in order to avoid any potential issues that may arise. So what this means for businesses. Well, for businesses so far, you're dealing with flexible working from day one. You're paying statutory sick pay from day one. You have neonatal care leave coming in. And proposals moving into 2026 that are going to significantly impact. This is open to opinion, but this is only a pick of the best bits. To prepare for these changes, this is something that we will be doing actively on your behalf to ensure that come 2026, we have everything in place. The main changes you're going to have to look at is enhanced recruitment procedures, pre-employment vetting. That doesn't mean that we all suddenly go out with a health questionnaire and. It just means that we need to ensure that all our processes are up to date and compliant. Go back to the Fair Work Agency and the powers that they are potentially going to have. It really isn't worth the risk of not putting things in place for a matter of, £5,000. Strengthen your procedures for assessing the performance of new hires during their probationary period. Tighten up your probationary period. That's it in a nutshell. What it means now, so with the changes already, let's review your current policies and procedures to ensure that you've got best practice as well as legal compliance. While this bill represents a broad framework of changes that are not enforceable until late 2025-26, it gives you time now to try and get any potential updates, changes, etc. in place before the changes become effective. If you haven't got your changes that are in effect, i.e. flexible, neonatal, etc., if I can ask you to get in touch with your lawyer or myself, we need to get that in place for you. Lots of details still to be decided. Again, I know I'm going on, but you need to be aware of the proposals. Take initial steps to consider how these coming into effect will impact your business. Do some critical decisions within the next 12 months before restrictions on rehire and fire come into effect. How will recruitment and retention strategies change in the light of the increased protection against unfair dismissal? Those are sort of 4 points that I thought were things that came to mind when I was reading through the bill. And if anyone really fancies it, it's good for insomnia. But it is something that we need to take pretty seriously at this point. And as I say, if you can get in touch with either myself or your lawyer, if you haven't got things in place, we will get that get that sorted for you ASAP. And with 3 minutes to go, I'd like to say thank you to everyone. It's very strange still doing webinars. It would be nice to get into a seminar scenario again, but has anyone got any questions? I am available on my email. If anyone has anything else, and we will also, if anyone's got any suggestions, actually, let's make this proactive. If anyone has any suggestions on what you'd like to hear in another webinar, please feel free to touch base and let me know. I would like to put things together that you all find useful, rather than me just sit here talking about things that I find interesting or not, as the case may be. There have been some interesting cases recently, so it is something that we can touch base on again. Any questions from anyone? Yes, we're going to be sending the slides out, and I think there will be a recording available. And as I say, if you do have any questions, what I would say is don't panic at the minute. We will get everything in place, and you know, there is much argument about, is it good, is it bad, is it indifferent? Time will tell, but I think, you know, as long as we do what we need to do, then... Oh, I've just heard that you should receive the recording in the next few days. No questions from anyone? No? Good, I'm glad you found it helpful. And as I say, any suggestions for future webinars, please let me know.